Hi, everybody. Thanks for coming. Really excited today for Brian to give his presentation on this. It's been a wild couple of years for landlord tenant laws and other real estate and legal issues. So we're really happy that we have a sponsor for today's presentation. It's Peak Goldstone LLC out of Greeley and Erie. I believe they have offices in both locations. And today, to introduce Brian, we have shareholder from that group, Miss LaPont, who is on and will introduce Brian. Thanks.
Thank you, Sean. So today our speaker is Brian, and he is an associate attorney. It's Brian Allard with Lyons and Gaddis PC. He practices in the real estate and business section of the firm's transactional group. He's an experienced litigator and transactional attorney. His practice focuses on forcible entry and detainer actions, mechanics liens actions, business disputes, property disputes, and some probate actions. Brian also assists clients with real estate purchases and sales, business purchases and sales, leases, liquor licenses, and business entity formation and operation. He is currently the president of the Friends of Longmont Museum. He attended Willamette University College of Law, where he received his JD in 2015. He graduated cum laude from the University of Missouri with a BS in Business Administration in 2012. Brian practiced in Missouri and in Kansas prior to moving to Colorado in 2019. In his free time, he enjoys snowboarding, hiking, and camping with his wife. There you go, Brian.
Thank you. All right. Let's see if I can go and get my share screen here, and I'm having difficulty, so hold on. Yep, that's not the screen. Yeah. All right, are you all seeing the PowerPoint now?
Brian, it's still your login as far as I can tell.
Come back. Sorry about technical difficulties here.
And this is kind of with the Boulder Bar again. I'll mention, since I forgot, as Brian fixes that he is happy if anyone has any questions in real time, you are able to unmute yourselves and just go ahead and ask those. He might pause a moment or two during the presentation to prompt you to do so. And then if you don't feel like asking your question in real time, you're welcome to send it in via the chat. And then either Sean or I will MC those questions at the end. Thank you.
Kyle, is it now showing my screen?
It's still your password page. You may want to stop your screen share and reshare.
Are you trying to share through RDS?
No. Sorry about this, guys. Let's see here. Share screen.
That looks good.
There we go. Sorry about technical difficulties, everyone. All right. So let's go ahead and get started here. So just at the outset, the changes that have occurred for the 2023 legislature, they are only dealing with residential landlord tenant laws. We haven't seen any changes as far as commercial goes. So just continue doing the things as normal with commercial. My understanding with the 2023 legislature is they were very focused on affordable housing. And as we know, in the real estate world and things along those lines, it's a hot topic. That being said, we do expect and anticipate bills to be introduced in 2024 that may also make further changes to these laws. I've heard one of the laws that didn't pass in 2023 but may come up again was the just cause law. But we'll see how this legislature runs through all that, and if we have any further changes coming forth. This has already been a lot this year, and as we go through these slides, you'll find that not only is it just the individual statutes that have been changed, but also there has actually been some case law that's created some some real issues depending on who your clients are or the situations that you're dealing with. All right, so the first law, and this one's kind of the brunt of it, the biggest one, as far as court actions. I'll have a couple slides on this particular law, but this one, it was effective as soon as it was signed by the governor, effective June 6, 2023. And as typical, these types of laws, it became effective immediately because it was, it was dealing with health and safety, or at least that's one of the reasons and rationales. So what this law does is, prior to a complaint being filed, there has to be an opportunity to mediate in certain aspects. So these will apply to, and you can read on the slide, and I'm not going to read directly from the slide as we go through all this. So you guys will have all the information here, and you also have the statutes you can go look at yourself. So if you have any questions on any of that, you can look at it specifically. But that being said, mediation is required for those that receive supplemental security income, Social Security disability insurance, or cash assistance under Colorado Works. And the way this works is, and what we'll see in the next slide, is they need to let the landlord know that they receive one of these and that they are requesting mediation. So if you file a lawsuit today to get someone out, or you file a lawsuit for possession, that is, you have to have an affidavit attached to your complaint that either says, hey, they never told me that any of these apply to them, or they don't actually have any of these, or we provide mediation on our own because we're a nonprofit or something along those lines. So if you don't attach that affidavit, they have an affirmative defense. So it's very important that you start with the complaint, and that you start this process and understand that now we're required to do these pre-suit mediations. And our firm has actually not done a mediation through the state or this Office of Dispute Resolution yet. All of the demands that we've sent out and things along those lines, we've never got a tenant actually disclose back. Before we started this call, Ms. DuPont said that she actually had one. So they are actually occurring and they are happening. But it is important to also know that the landlord is required to pay for that mediation as well. So that's going to be kind of your first step in going through. If I'm going to file this complaint, I also have to make sure that I'm attaching an affidavit saying, hey, they didn't let us know, or wherever, so that we can do something along those lines. We practice quite a bit in Boulder County, and this mediation requirement's been kind of interesting for us as well, because in Boulder County, judges are actually requiring mediation at the possession hearing or before the possession hearing actually occurs. So the individuals that are here in Boulder County and file an action basically get two opportunities. They have the mediation stuff spelled out in the demand, but then right whenever we go to the possession hearings, they also have an opportunity again to mediate by court order there in the courtroom. So most of our cases we do see get mediated, and it can be very helpful for the landlord to mediate these cases because you can usually enter into some type of stipulation that will get them out in a reasonable time and kind of move forward. If you need to, if they somehow break that stipulation or anything along those lines, you can quickly go into court and get something to get them out. So mediation, in our experience, has been very helpful. It's interesting at the statewide level how this is playing out and how it'll play out in different courts. All right, so kind of going back, this is the same bill that was passed, and the important piece here for us is the demand for compliance. You actually have to have a statement in there that's written that says, if you receive supplemental security income, Social Security, disability, or Colorado, or you get assistance through Colorado Works, you have a right to mediation. If you go on the form documents for the Colorado website, you'll find that the updated forms actually do have that provision in there. But one thing I do want to quickly go back to, on the first part of the statute, it says that any complaint filed must have the mediation requirements, and it doesn't specify between a demand for compliance or a notice to quit. So we've been providing this notice in our notices. We've also been putting in the mediation piece as well, just because the statute is not real clear, and it requires the affidavit for any complaint. It doesn't specify between a notice to quit versus a demand for possession. We've been doing that. It's kind of the conservative route, just to make sure that the tenant in these type of situations doesn't have an affirmative defense. I think one of the things too, just to mention across the board, we typically represent landlords in these actions, so this is kind of why we go through this process a little bit more. We do a little bit of tenant work, but most of our work is landlord work. So they've also changed the writ of restitution, and the form on that as well is on the Colorado State website. The biggest change that has occurred is that if the tenant is getting those three things, again, the supplemental security or disability, then we have to provide 30 days on the writ. So they can't execute it on it for 30 days. So those individuals that represent landlords that are doing affordable housing, things along those lines, you just need to be able to tell them at the outset that it's going to take a lot longer. This whole process is going to take a whole lot longer. A little later in the slides, I'll also talk about a case that has changed even the notice requirements, or at least the ideas behind the notice requirements. So big impact on affordable housing. The writ of restitution hasn't changed as far as the 10-day stay on it for the sheriff to act on any other resident. So you can get your writ after a possession hearing, but the sheriff will not be able to execute on that for at least 10 days. Those are, again, in the form documents. You'll see a check mark for the 10-day versus the 30-day, and typically the judges are pretty familiar with those, but just know that that's going to be kind of how you're walking through. This is just a further piece of the same bill. It doesn't have a whole lot as far as one of the pieces is because we've now been talking about supplemental insurance or supplemental income and things along those lines. It doesn't constitute unfair housing to ask about that. So that's been clarified as far as things go. The other piece is this rental agreement piece that we'll talk a little bit more on another statute that's come out. But what they're really trying to get after is income discrimination and issues that can go on with that. You can still ask about income, but there's just still issues as far as how much you can ask and what you can rely on whenever you're renting to an individual.
Brian, excuse me,
Yep.
this is Alicia Villarreal. What does the term non-exempt landlord mean?
I'm sorry, and let me see here.
It says CRS prohibits source of income discrimination and requires a non-exempt landlord to accept any lawful and verifiable sources of money.
You know what? I'm not actually, I pulled that from the statute, so I'm not entirely sure.
Okay.
I can look into that and get back to you though.
It's just an interesting term.
Yeah, it's pulled directly from the statute.
Okay. Thank you.
Yep. All right. So this one's going to be effective in January, or these two laws. And so as we go, a couple of these laws, we haven't seen them actually come in. So one of the issues here too, and as you'll see, is you may want to start looking at with your clients updating leases as we start the new year. If they're going to be rolling over or doing things along those lines, there's just going to be some new laws that are going to come into effect. A lot of these laws too, just so you know, on the effective date, they could be challenged, by a referendum or something along those lines. But they should be going in effect per these dates. And I think there's something in the chat. Yeah, I believe actually Brett just had said something about the non-exempt versus exempt landlord. And I believe that is correct. It's how many homes you actually have and actually are renting. I know that a couple of these laws, if you have more than 5, is going to be what it's going to apply to. But I will confirm that. All right. So residential county court actions. This is just a piece that you all should know that if they're going to be allowing WebEx for a lot of hearings, we're pretty used to this at this point with COVID and so on and so forth. I think that's going to be one of those that the courts are recognizing that it's really could be a way of access to the court system. And so they've now put it in statute that people can appear via WebEx for these county court actions. I know a lot of the county courts already do this, so it's not going to be a major change as far as things go. In addition, the one other piece that they've added, which is kind of interesting, is that if a pro se defendant is filing for a waiver of fees, the court can actually request documentation for them, and they can wait up to 24 hours to rule on that. So that could delay, just thinking about it, and issues that could come up as far as if an answer is filed. And I know, at least in Boulder County, you can file an answer up till 5 p.m. the day of possession. If they have to wait 24 hours to see if the fees are waived, you may not know for sure if it's going to be accepted by the court, until a couple days down the road. So kind of an interesting piece on that, but that's what that law says. Got another question in the chat. Oh, and here we go. Sean jumped in with the exempt stuff, so you guys can read through the chat. So the other piece is now pets in residential leases. I want to put a caveat just to all of this. You're not required to allow pets in residence. This law doesn't say that, but it does say that if you do allow pets, there's going to be certain requirements with it. First of all, insurers cannot they can't refuse to insure or renew or increase premiums based on the breed of dog that's in a lease space. In addition, if the sheriff goes out and serves the writ, and they know that a dog or an animal is in the residence, they either need to give that to the tenant, or if the tenant can't be found, they need to put it to the local animal control. And then for the individuals that represent landlords, they need to know that if that does occur, they need to post a notice to the tenant so that they can potentially find that pet. The other thing, and this is going to be kind of important as far as if you guys are reviewing leases and things along those lines, they now have a cap on security deposit and also additional rent that can be put in there. So the cap's $300, and then the additional rent is $35. Okay, whoop, back here. So this is kind of a long slide, and there's a lot of information here, and I don't want to spend a ton of time on it. This one you guys can read through and kind of get all the specifics on it. What it deals with is portable screening, and portable screening basically is the idea is the tenant goes out and they get their own credit report or consumer report with criminal background. the landlords can't go out and just deny someone them providing that. They can put parameters around it. So if a tenant comes and say, hey, I've done this portable screening, they can require that it be within the last 30 days. They are required to put postings on their listings and stuff that they will accept some form of portable screening. And there are specific exceptions as far as things go, and you can read that in the fourth bullet point. But again, these are not two major changes and may not apply to every situation, but it's just something that has changed and things along those lines. I think the other important piece is that there are actual damages built into this statute. So your landlords definitely need to know about it. They could be charged up to $2,500 for a violation, and plus attorney's fees and cost. Fortunately, if they cure the violation, they can only be charged up to $50. So something to definitely be aware of and be advising your clients on as far as that goes. Okay. So this kind of goes back to the original slide as far as the income and rental history requirements. This was what as far as the piece of amount of income that the landlord can look at. They can look at financial information, but they have to be very narrowly tailored. The second bullet that's kind of indented has the specifics on it, and I'll just read that. Amount of income except for determining if the income equals or exceeds 200% of the annual cost of rent or the prospective tenant's credit score, unless required by federal law. That unless required by federal law is going to probably apply to the supplemental insurance or supplemental income of some sort. But again, if you're going to look at income, it can only be to 200% of the annual cost of rent, or if you're looking at their credit score, again, you need to be making sure that it's just based on what are they going to be able to pay this rent, and is it going to be within that 200%. The other important piece here is that for security deposits, and this could be a big change for a lot of people, is that you can't have more than 2 months rent as a security deposit. So that's something to be paying attention to in the leases. We want to make sure that those are, that they're not overcharging for security deposit, because that provision could be a real problem. Then as far as prohibitions and rental agreements, I put a whole lot of listed in here. You guys can read through all the specifics on that. And you can also read the statute. But I do think I want to point out two important things on this as well. One of them is that you cannot have a provision in the rental agreement that a jury trial can be waived except for a possession hearing. So I think that that's a very important caveat to this particular law. One of the issues that you run into is that possession is one. A lot of these cases are bifurcated. So the possession, you can have a waiver for jury trial, but for damages and so on and so forth, or any other issues that may arise, you can't have a jury trial waived. As we've already known, this has actually been a law in the past, but it's just important to make sure of is that you can't have a one-way fee shifting provision for a prevailing party. It needs to be for a prevailing party, and we need to make sure that our fees are reasonable. Got another thing in the chat. And Dean Hill's asking about the affirmative defense provision. Yeah, so I'm sorry. It's an affirmative defense for the tenant if the landlord is asking for. So if they file an action or do something along those lines, and they ask for more income, or The other issue that could arise as well is that failure to rent or do something along those lines, the tenant could create an affirmative defense based on that. So I don't know if that answers the question or is specific enough, but we'll see if a chat comes up any further. All right. All right, so for the folks that also do beyond landlord tenant, also do real estate work, this is an important law to pay attention to. It's for radon requirements. So this is actually going to apply to the to sales of properties in addition to landlord tenant. So definitely take a look at this if you're not already aware of it. As far as things go, I do know that the form documents for the real estate group and things along those lines, they actually do have the radon requirements in there. So as long as you have an updated form, you should be good as far as things go there, but just something to be aware of. As far as landlord tenant goes, though, there aren't specific forms that I'm aware of. So you do need to go ahead and review those statutes and include these as an addendum to a lease or as part of a lease. And make sure that they understand that, it really is important that they're disclosing, the landlords are disclosing if there's any radon. There's actually a brochure on the Colorado Department of Public Health and Environment that you can get on and actually show and actually provide to the tenant with all the potential risks of radon and things along those lines. Make sure that with the addendum or that addition, that there's an acknowledgement by the tenant of receipt of the radon issues that could be there on the property. If you've done a radon test, you do need to provide the results of that to the tenant as well. So just important to understand that if the landlord fails to be doing this, they could be breaching the warranty of habitability. So it's important that that we follow these laws and that we understand them. Okay, so here's been a pretty big case. This one came out in May, and this is only going to apply to landlords that receive funding of some sort, supplemental funding or Section 8 housing, HUD, things along those lines. What this case was about was the CARES Act and COVID-19. Kind of a surprise opinion, and it could have some pretty broad implications. First of all, what they did is they interpreted the notice requirements under the CARES Act, which when the CARES Act was enacted, it was only permitting a 30-day notice for move out. And that particular law was interesting because it actually had said it was a temporary law. That being said, in this particular case, a tenant was served with a 10-day notice under Colorado law and to move out. The landlord sued the tenant for possession, and after the fact was hit with an answer and a motion to dismiss. The answer and motion to dismiss basically said you need to provide 30 days notice under the CARES Act. So this wound up at the Colorado Supreme Court, and the Colorado Supreme Court looked at the language of the COVID-19 CARES Act and noticed that the notice requirement was a separate provision under the law, and it didn't actually have an end date to it. In interpreting this, and with actually other states as well, doing similar actions, they held that before you could file an eviction action for a Section 8 or something along those lines tenant, the landlord had to provide 30 days notice. This is a very broad ruling, and one of the issues that could run afoul, and I don't know of any test cases yet or anything along those lines, but if the tenant's committing a substantial violation which would only require a 3-day notice. Under this law, it could certainly be argued they'd still get 30 days. We actually represent a housing community that's experienced quite a bit of meth issues and things along those lines. And it'd be very difficult to have a situation where a tenant is doing meth in the property, creating all kinds of damage, and the best we can do is potentially a 30-day notice. I think in those cases, I think we still need to push forward and see where we go with the 3-day notice, but this is a very broad ruling and could have some very broad implications. All right. And this is the final case. And all this really has to do with is a warranty of habitability complaint. This particular tenant had a ton of issues going on, and he reported orally and written to his landlord a number of different issues that you can read in the facts here. But really, what the question for the court in this situation was whether or not the warranty of habitability, whether you had to follow it strictly or if you just could be, in substantial compliance. And one of the issues, particularly in this case, was whether or not in a non-emergent situation, the tenant had to not only provide written notice, but provide written notice with permission for the landlord to come in to the premises and actually fix the issues. The finding of the court was that they must strictly follow that written notice. And so it's not a breach of warranty of habitability unless they are actually following it strictly by the statute. So they need to be provided written and not oral demand or oral or written notice of what was going on. But it also needs to be in a non-emergent situation. Hey, you can come into the property and fix this. All right. Now I went through that pretty quickly. So we've got plenty more time if anybody has any specific questions. One thing I would definitely say is, you can look back at these statutes. There's a lot of information in these slides, but there's a lot more too in the statutes themselves. And we'll just see how this next legislature plays out and where we're at. So does anybody else have any particular questions or comments? Here's my information too, if you want to contact me as well.
So, Brian, I have a question about the radon testing.
Yeah.
If you're representing the seller of a property that has not been radon tested, then all you need to disclose is that fact. You don't need to go out and get a test and then provide that to the buyer.
That's my understanding. Yeah. And you do provide the brochure and things along those lines to let them know of, hey, you should probably look into this, so it's not a requirement necessarily that you're doing it, but it's something that you're notifying them.
Okay. Thank you.
Mm-hmm. Well, I don't think anybody else have anything? Not. Yeah, went through that pretty quick.
Just piggybacking on Brian's thing, John, there's statutory language too, that specific statutory language that goes in the brochure and that disclosure, even though you're not going to do testing, sort of similar to how they have the special district and HOA required stuff for residential sale contracts.
And also just to dovetail to that, the statute itself actually even has language in there in bold. You can pull it straight from the statute, throw it in to things you need.
Natalie's asking if you can make the PowerPoint available. I think Kyle will do that. I could be wrong, but I think
Yeah,
Kyle's
I
gonna
believe
send out
so.
the-
And I found a typo too. So I'll be updating that and Kyle can send it around. Yeah, that's an interesting question. I don't know about the boarding fees. I don't know anything specifically. Just so everyone knows, there's a question in the chat about whether or not if you send the pet to animal control, whether the tenant can be assessed boarding fees. I don't know anything specific on that. As far as the pet stuff has gone, I really was, it was more on the writ of restitution and things along those lines. I didn't see anything about the boarding fees, but it's a good question.
Anybody else, or just thank you to Brian then if not.
Excellent presentation, Brian. I learned a lot. Thank you.
Of course.
Thanks, everybody.